The honourable member for beautiful Langley.
Thank you, Mr. Speaker, and it's a real honor to participate in the second reading of Bill C-26. I'll be sharing my time with the hardworking Minister of Heritage, and I want to thank her for her work on these important files. She has a huge heart. Since I got to know her a number of years ago, she's one of the most compassionate people. And she actually has a police officer background, and so I can only imagine how caring and the good work she did when she was a police officer before she came here. I also want to thank the NDP and my Liberal and opposition colleagues for their commitment to support this C-26, demonstrating a concern to protect the victims of sexual assault, and also their commitment to support our Victims' Bill of Rights. It's the right thing to do, and as a House to come together on these important pieces of legislation, it's very encouraging for myself and I think for all Canadians. Bill C-26 is another concrete initiative of our government to combat all forms of child sexual exploitation. It aims to guarantee that sentences imposed for sexual offences against children reflect the gravity and reprehensible nature of these offences. One of the ways that this bill proposes to attain this objective is to ensure that those who have committed sexual offences against children do not receive a sentence discount for cases where there are several victims. In order to better understand these proposed amendments, I think it's important to consider how sentencing is carried out in cases involving multiple offences. Subsection 718.3, Clause 4 of the Criminal Code contains the general principles that reflect respect to the nature in which sentences imposed in multiple offences are served. That is, when they should be served consecutively, or which is at the same time, or consecutively. Unfortunately, that provision is an amalgamation of legislative provisions, most of which have existed since the first Canadian Criminal Code, and the text itself is difficult to read. As a result, that provision provides little guidance to the sentencing courts. This bill proposes to clarify its content. When sentencing an offender at the same time for several offences, courts have the discretion to order that the sentence be imposed and served one after another, and that's called consecutively, or at the same time called concurrently. Over the years, the Canadian courts have developed an approach whereby they will generally order that the sentences are served consecutively unless the offences arise out of the same event in a series of events, in which the case concurrently sentences are usually imposed. In assessing whether the offences arise out of the same event, the courts will consider, for example, whether the offences have a real or temporal connection, or whether these offences have any logical connection to one another. Mr. Speaker, this rule is not absolute, though. Courts acknowledge that in some cases the sentences imposed for offences committed as part of the same event or a series of events are such that they should be served consecutively. An example of this approach is reflected in situations where an offender tries to evade police after committing an offence, such as an armed robbery. The general rule is that in such a situation, the sentences imposed on those offences would be served concurrently, but courts will generally impose consecutive sentences on such situations in order to reflect the reprehensible nature of an offence committed in such situations. Courts will generally follow the same principle in situations where an offender who is on judicial interim release, otherwise known as bail, commits another offence. So the offender is serving an offence, is out on bail, and recommits another offence. Courts generally agree that a sentence for an offence committed while the offender is on bail should be served consecutively to the sentence for the offence for which the offender is initially on temporary release. To do otherwise would send a message that there is no consequence for the offence committed while on bail. This bill proposes to codify these sentencing approaches by directing the courts to consider ordering that the term of the imprisonment imposed be served consecutively to any other sentence of imprisonment, particularly when the offences do not arise from the same facts. Mr. Speaker, it's also important to note that the totality principle, which is found in paragraph 718.2 Clause C of the Criminal Code, requires that where consecutive sentences are imposed, the combined sentence should not be unduly long or harsh. Where this is the case, this principle provides courts with the discretion to impose concurrent sentences where the consecutive sentences would otherwise be unwarranted. Mr. Speaker, although there is a great level of flexibility provided to the courts in the determination of whether it's concurrent or consecutive sentences, the Criminal Code directs courts to order that the sentences imposed for certain offenses, serious offenses, be served consecutively in all cases. This is the case for the offenses of possession of explosives for a criminal organization, the use of a firearm in the commission of an offense, terrorism offenses other than where the sentence of life imprisonment is imposed, and criminal organizational offenses. As I mentioned in my opening remarks, the main purpose of this bill is to ensure that people who commit sexual offenses against children receive sentences that reflect the gravity and reprehensible nature of these crimes. In addition to the proposed higher mandatory minimum penalties, the higher maximum penalties for certain sexual offenses against children, this bill proposes to add the sentences imposed for multiple child sexual offenses to the list of mandatory consecutive sentences in order to ensure that it fits the sentences. Mr. Speaker, the proposed amendments would also direct a court to order that the sentences imposed for child pornography offenses be served consecutively to sentences imposed for other contact sexual offenses against a child. For example, let's consider an offender who is sentenced at the same time for assessing and making child pornography, as well as sexual assault of a person under the age of 16. The proposed amendment would mean that the sentences for child pornography must be served consecutively to the sentence for the sexual assault. This approach aims to recognize in part the court's practice of imposing sentences that effectively recognize the heinous nature of sexual offenses against children, and particularly child pornography, especially when it's distributed over the internet and is thus made permanently accessible around the world. The proposed amendments also target situations where there are several victims and would require that sentences imposed at the same time for offenses involving sexual abuse of one child be served consecutively to sentences for sexual abuse offenses committed against another child. In many respects, the proposed amendments would bring greater uniformity and certainty in future sentencing practices, particularly in the context of child sexual abuse cases. The bill proposes to approach that clearly reflects the government's commitment to ensure that sentences for sexual offenses against a child better reflect the gravity of these offenses and make all child sexual offenders answer for the exploitation and the sexual abuse that they have committed. The proposed amendments would particularly end volume discount for sentences given to offenders who have committed multiple sexual offenses against a child, and to ensure that each victim counts in the sentencing process. Mr. Speaker, I encourage my colleagues in this House to unanimously support this bill without reservation. I think that is coming, and I look forward to that vote. Thank you.
Questions and comments? The honourable member for Charlottetown.
Thank you, Mr. Speaker, and I thank the member opposite for his speech. We share the goal of there being fewer victims of child sexual offences. I think we all share that goal in this House. And I think it's therefore critically important that we seek ways to reduce the number of victims that are effective. The mode of choice for this government is mandatory minimum sentences. And there were mandatory minimum sentences introduced in Bill C-10, which came into effect in 2012. And since then, the incidence of child sexual offenses has increased. And so the answer in C-26 is to take those mandatory minimums that we had in C-10 and increase them. Given that that hasn't worked, would the member agree with me that we must be more creative in trying to create less, in trying to cause there to be less victims than to keep doing over and over again what isn't working?
The honourable member for Langley.
Well, thank you, Mr. Speaker, and I thank my friend from Charlottetown, and I know he has a legal background, and I appreciate his commitment to participate in the debate and also share his concerns about children being sexually exploited. I also appreciate his goal, which is the same as the government's, is to reduce the number of victims of sexual exploitation in Canada. Now, we may not agree when mandatory minimum sentences are appropriate. And we've consulted with Canadians, and we continue to consult with Canadians. And the fact is, Mr. Speaker, Canadians want more mandatory minimum sentences than what our government is proposing. And we have to reach that balance. And I look forward to continuing working with my friend across the way, that we try to find that balance, make Canada safer, represent our constituents, and amend the criminal code where appropriate. Thank you.
Questions and comments? Question of the honourable member for Kildonan St. Paul.
Thank you, Mr. Speaker. Mr. Speaker, repeatedly this morning I've heard, what is the use of mandatory minimums? Repeatedly I've heard because there's an increase in child sexual exploitation that mandatory minimums aren't working, and repeatedly I've said they are working. They keep the perpetrator away from the victim. Also, there's more and more victims coming forward. Why? Because now we have the laws in place where the victims know that they can be protected. The parents of the victims know they can be protected. So I would like to ask my honourable colleague, and I want to thank my colleague for his unending support of the protection of young children, especially on the human trafficking file. I want to ask my colleague, what can he tell me that he feels is the most important point in this particular bill, because it does break the ice in a lot of areas in terms of the protection of children.
The honourable member for Langley.
Mr. Speaker, I want to thank my colleague, who I consider a dear friend, who has been recognized around the world for her work on protecting children and women that are being exploited, her fight against human trafficking. And I mean, we applaud you. We thank you for your work, and we hope and know that you will continue to do that important work in Canada. Mandatory minimums are very important. The courts must maintain discretion, and they do. If we pass legislation asking for mandatory minimum and it does not meet the charter test, it will not stand. But many of the mandatory minimum sentencing that we have now in toughening up the criminal code, they are supported by the charter. And when they're warranted, they're needed. There's another one, Mr. Speaker, that I've been asked by constituents to work on and get mandatory minimum sentencing for people convicted of killing somebody while impaired, driving impaired. And they want mandatory minimums. They believe the criminal code needs to be changed in that. And so I believe there are appropriate times to make these changes, and I hope we can meet that balance in this Parliament.